Welcome to the Half Empty, Half Full radio show on the Starcom and Tan Talk Radio Network with your host, Lori Zook, the consumer champion. All opinions are that of the host and guests. Do you have a story idea? Contact us on our Facebook page, Half Empty, Half Full. We want to hear from you. And now, your host, the consumer champion, Lori Zook.
And welcome to the show. Each week, we'll be discussing problems and solutions, changing negatives to positives, and helping you, the consumer, to get smarter faster. My guest today is attorney Townsend Belt, and we're going to be talking about what you as a consumer need to know about landlord and tenant law. Now, Townsend is not giving legal advice. The show is strictly educational, but it's going to help you if you tune in and listen. I want to welcome you to the show, Townsend, and if you would share with our listeners a bit about yourself and your background.
Well, I'm an attorney, and right now I practice in Tampa, Florida. We cover basically any place from as far north as Citrus County or so to as far south as Sarasota or Manatee County, and then as far west as the Gulf, and east as far as Polk County.
Okay. Now, you handle all types of legal matters. Can you talk about that a little bit?
We handle a wide range of legal matters. My areas that I practice in primarily are commercial litigation, landlord-tenant, and real estate law. I also practice in insurance litigation, which is how the firm that I'm with, Florida Advocates, got started, was basically in PIP. But we handle all manners of insurance litigation, from basically personal injury protection benefits to homeowners insurance, pretty much anything you can think of that is a first-party insured making a claim against an insurance company.
All right, well, let's jump into the landlord-tenant stuff. What are the laws, governing landlord-tenant relationships in Florida?
Well, in general, landlord-tenant relationships are governed by two things, at least. One is by statutes, and the other one is by generally a contract, what we would refer to as a lease or a rental agreement. With regard to the statutes, the primary one that we're going to talk about, I think, today is going to be in Chapter 83 of the Florida statutes, and it's Part 2, the Residential Landlord and Tenant Act.
Okay. Well, you talk about the stat now. What's the difference between, you said, the statutes? Explain what a statute is to begin with. It's a federal law, a state law?
Well, there are both federal and state laws that apply to landlord and tenant relationships. A couple of examples are basically the legislature in Florida has enacted several laws that regulate landlord-tenant relationships. Part 1 of Chapter 83 handles non-residential landlord-tenant relationships. Part 2 is residential landlord and tenant. Part 3 is self-service storage. There's also a Mobile Home Act that covers mobile home relationships. There is the Disposition of Personal Property Landlord and Tenant Act that deals with what a landlord must do if you leave property after you've left the unit. And then there are federal laws that have been enacted that also apply, and those would include the Federal Fair Housing Act, the Civil Rights Act, the Americans with Disabilities Act, and then there are a bunch of other ones that apply too in certain circumstances, including depending on whether or not it's a subsidized apartment. There's other federal laws that apply there. So
okay, well, let me go back then to the statutes. Let's go back a little bit so we can explain what they are. What's non-residential?
Non-residential, and I suppose it's somewhat defined the other way. The non-residential part of the Chapter 83 applies to that which is not residential. And so when we look at what residential is, I would look at it and say if you're renting some place for you to sleep there, as in for us to reside there, that's how I would look at it. But that there's also an exclusion from that too, and that doesn't include hotels. But it would include something that you might not think of as a normal landlord-tenant relationship, which is, what if you're working for a company and as part of your compensation, they provide you with a unit or a building that they own for you to live there. In that case, then sometimes the Residential Landlord and Tenant Act can apply as well.
All right, now what about self-service storage space? I mean, I know I've rented storage, and I actually took out a policy through them because I couldn't get one on my own renter's insurance. Is that so? How is somebody protected under the self-service storage space?
I'm not sure how we would look at it as how somebody's protected. It's just that that's the Florida statute that applies to it and governs the relationship regarding if you're going to leave your belongings there.
Okay.
That also is governed by, in general, a contract. But I think for our purposes today, the main thing that consumers need to be aware of is really Part 2, the Residential Landlord and Tenant Act.
Okay. Now you mentioned the Florida Mobile Home Act. So there are different laws if it's a mobile home versus just a regular, say, single family house structure?
Yes. The difference being, and it's kind of a practical effect that we can understand why there would be differences. One is that if it's a mobile home, you could either A, be renting the lot space and own the mobile home, in which case there's kind of a big difference if someone wants to evict you from the lot space than there would be if they were just evicting you from, let's say, an apartment. I mean, it's not just your personal property. They'd have to do something with the mobile home.
Okay.
The other way it would be is what if you're renting both? You're renting the lot space and the home, in which case, I would say at that point, it really is almost a purely Chapter 83 Residential Landlord and Tenant Act dispute, because now you're renting the structure. You no longer own it. So the landlord would not have a duty to basically, or would have a duty if the landlord owns the structure to maintain it as opposed to yourself.
All right, gotcha. Now you mentioned you could talk about each of these laws. For example, what is the Federal Fair Housing Act, the Florida Fair Housing Act? You have the Civil Rights Act of 1866 and the American with Disabilities Act. So maybe you can explain a little bit about those.
Well, I guess the gist of all of that is that essentially landlords can't discriminate based on race or sex. That would be your Federal Fair Housing Act, Florida Fair Housing Act, and your Civil Rights Act. And they also can't really discriminate based upon a disability. That being said, that doesn't mean that every unit that a landlord owns needs to now be handicapped accessible. It just means that if the most common time that I see this is that you can't go ahead and sell somebody that you're not going to rent to them because they have a disability. Or there's a question as to whether or not they really could ever charge you a pet fee for a service animal.
Right, because they're usually excluded. I know they allow service animals to be with people all the time, even if they're in a restaurant, for example, but they have to be a certified pet animal.
Right, and so if they're a certified service animal, then it would probably be found, and I have not seen a case in Florida that's addressed this, but it would probably be found to be something of a discriminatory action to say, hey, we're going to charge you a $35 per month pet fee on top of this thing, because that's really not considered a pet by the ADA.
Now, have you seen cases like that yourself?
Yes, I've seen it, but it was resolved prior to ever having to file suit.
Okay, so. And now a landlord, let's say they own an apartment complex, for example, and maybe it's an older complex that was built a long time ago. Are there any laws that require them to, for example, somebody is in a wheelchair? Are there any laws that say you have to have a certain amount of units? Just like when you go out into the parking lot, and there are the disabled parking spots. Do you know what I'm trying to say?
I kind of think I know what you're trying to say, and no, not that I'm aware of that they have to have a certain number of, say, handicap accessible units. And I'll kind of roll this back a little bit.
Okay.
The thought there would be to me is that if a landlord were to own, let's say, a fourplex or something, and they bought it and it was built in, 1965 or 1975, they wouldn't be required then to go and say, okay, well, we're going to take one of these units and make it handicapped, make it basically, put wheelchair ramps and put to the upstairs floor and do all of these things.
I gotcha.
Mainly, I look at them, and the cases that I see are acts of discrimination where you would see that the main one is really the pet is the one that I've seen the most. That they say, hey, my landlord is charging me a pet fee. Do I have this? Can they do that? And I say, well, probably not. But that's usually resolved upon a letter.
Now, is there a way for people that own these properties that they're renting out? It seems like a lot of them don't know what any of these laws are, and yet they're the landlord. And so I guess my question to you would be, how educated or uneducated do you think a lot of landlords are when it comes to knowing what the law is as far as the discrimination part of it?
Well, I would say that most professional landlords, and when I say that, that's their business, are pretty aware of what's required of them by basically all of the laws. It's worth it at that point to be educated about it. When you look at the landlords that I would say are not professional landlords, their landlording is kind of a second job for them, or it's something where they say, hey, I used to own a townhouse, now I moved in, I bought a house, and I'm going to rent the townhouse out. A lot of times I don't think that they're fully aware of what all of their responsibilities are under Chapter 83, much less the rest of the rest of the laws that govern landlord-tenant relationships.
Okay, now what are some of these other laws, the FDUTPA, FDCPA, FCCPA? How do those play in those laws?
Well, I kind of see those as being somewhat ancillary to the main parts of Chapter 83 that apply to residential landlord-tenant relationships. But the FDUTPA, as we call it, is the Florida Deceptive and Unfair Trade Practices Act. And it has been held in certain occasions to apply to landlord-tenant relationships. It's almost as straightforward as it sounds. If there's been a deceptive or unfair trade practice, then that law may apply to a landlord-tenant relationship.
Okay, can you give me an example of that one?
There's one case, and it was in the 4th District Court of Appeal, and basically what had happened was a tenant had leased a space from a landlord, and it did not comply with what the landlord was supposed to comply with, the laws regarding the building itself.
Okay.
And so the tenant alleged, amongst various other causes of action, that the landlord had violated the Deceptive and Unfair Trade Practices Act. And the 4th District Court of Appeal said, yes, the tenant was a consumer for that, or was protected by the act, and that the landlord was engaged in that business and therefore had to comply with, could not engage in these deceptive and unfair trade practices. And so they upheld, the court upheld what the lower court's ruling was, which was that they had violated the act. And so it's a very case-by-case basis or analysis, but that's how it applied there.
All right, well, we're going to take a quick commercial break, and we're going to come back in just a moment.
Time after time, I've done my sentence, but committed no crime.
Do you need a private U.S. address for your home business? Do you need help packing and shipping? Are you tired of keeping your inventory at home? Do you need a storage space to store your merchandise? HelpShip.com is a domestic and international shipping and packaging service company that can help you with your shipping needs. No matter where you live, we can forward anything to anywhere for you and your customers. Our services range from packing consolidation service, mail forwarding service, shopping assistant, and much more. We're rated A on Better Business Bureau. Expand your business to the globe with us. Please visit HelpShip.com for more information.
Do you suffer from back, neck, or body pain? Do you suffer from migraines or have jaw or face pain? Has conventional medicine failed you? Were you injured or in an accident? Call chiropractic physician Dr. Dan Maddock at 813-935-1664. Dr. Dan has helped thousands of patients gain relief for more than 30 years. Dr. Dan is caring, gentle, and takes his time with each patient. He's also a past president of the International Craniopathic Society, a special certification of only 300 chiropractors worldwide. Dr. Dan helps patients from the neck up and the neck down. Dr. Dan accepts most insurance plans. Don't continue to live in pain. Call 813-935-1664 today. That's 813-935-1664 and get on track to better health.
Time after time,
Welcome back to the Half Empty, Half Full Talk radio show. My guest today is attorney Townsend Belt, and we are talking about tenant and landlord laws. Now, Townsend, let's talk about the important stuff. Let's talk about the lease. Tell me about leases.
Well, what we usually refer to as a lease is referred to in Chapter 83 as a rental agreement. And what it is it's basically the other half of what a landlord and tenant relationship is usually governed by. There's no requirement under the Act or otherwise that there be a lease to create the landlord-tenant relationship. If there's going to be a term of a year or more, then a writing is required. But basically, the lease is the contract that's generally entered into when someone rents an apartment or a condominium or a house or some other place that they are going to sleep. It's not something like a hotel, as we had kind of spoken about earlier.
All right, so tell me then what the required terms of the lease must say.
Well, the lease underneath the Act has to identify, well, it should identify the landlord and the tenant, and it should identify the dwelling unit, which is what the Act refers to as the space that's being rented by the tenant. The other thing is that there are certain provisions that are required to be in a residential lease. One of them is that it must disclose in writing the name and address of the landlord or a person authorized to receive notices and demands on the landlord's behalf. And that provision is, in my view, extremely important to the tenant, and we'll probably touch on it a few times throughout our conversation today, because certain rights are only invoked by the tenant if they give notice. And it's very important that this place to receive notice is identified in the lease, not just so that it complies with the Act, but also so the tenant knows, hey, I've got a problem. This is where I notify the landlord.
Gotcha. All right, so they have to know how to be able to reach. That would be an issue. If you don't know how to get a hold of the landlord, it's almost like they're hiding.
Right.
At that point.
A good instance of that is there's a terrible roof leak. The lease probably requires you as a tenant to report that to the landlord. If there's no good place to tell, and it also probably is a violation of the Act under 83.511 as far as the landlord's maintenance of the structure. But for you to notify the landlord, you need to have a place that you can do that. It probably will say inside of the lease or the rental agreement how notice should be given, whether it is by certified mail return receipt requested, by hand delivery. And it's a very important provision inside of a lease to pay attention to. Another provision in the lease that's required really applies, and this was changed by the legislature in 2013. The landlord, if they rent more than 5 dwelling units, so think about if they have a sixplex, this applies. If they own 5 houses that they rent out, it applies. If they've got a duplex and 3 houses, this applies. If they have more than 5 or more dwelling units, then the rental agreement needs to contain certain information or certain statutory language that addresses security deposits. If it's not there, then the lease violates, I would say the lease wouldn't comply with the Act, with the Landlord Tenant Act. So you should always look to see where that's addressed as well. That's a very important, I'd say the 2 most common issues that I find from consumers is, number one, there's a problem with the space, like either think about like a mold problem, there's a problem with it it's in bad repair, or the second one is, hey, I moved out and what do I do? When do I get my deposit? And so the provision regarding the deposit is going to be probably governed by your lease. If not, it's identified in the statute. If not, and the other one is 83.51, which we'll probably touch on a little more in depth in a few minutes.
Well, let me ask you a question then. What if someone listening here, is listening to you talk about this? What if they realize that their lease doesn't contain these certain terms or these certain elements, and maybe the landlord hasn't complied with the law? Now maybe they have a problem. Maybe the roof is leaking if they're renting a house, but they realize that agreement is not complying with the law. What happens in a case like that? I mean, if they, you know what I'm saying? How do they protect themselves? Like I was always taught if to put everything in a letter, certified return receipt, mail, and that works fine unless, what if you have an emergency? What if there's a flood and a water line breaks in the house and you have an emergency situation?
If there's an emergency situation, then exactly like you said, there's a flood in the house. Certainly, you can go. You need to go ahead and provide notice as soon as possible, just so that somebody can come in and make the repairs. Also, so that you can. You probably have a duty to report that. Just to go ahead and say, hey, by the way, there's a problem here. That being said, there's a specific section in the statute that discusses what caused that emergency. It's going to be a factual determination. Is the emergency caused because, hey, by the way, I was filling the tub up upstairs, plugged the drain, and
the tenant caused the problem.
And the tenant caused the problem. Well, that's one situation. The other situation is, what if it was that lightning struck the roof of the structure?
The act of God, right?
An act of God type of situation, and then the structure, then the place floods because water comes pouring in. And so each of those would be determined differently. In the first one, it would be the tenant's negligent act that caused it, and the tenant has probably not lived up to its duties, or I say it, but the tenant, I was thinking more of a commercial standpoint.
Right.
But the tenant has probably not lived up to his or her duties of maintaining the dwelling unit because now they've been negligent and damaged it. The other case, there are a couple of things that can happen. If the premises is left completely untenantable, is the word used in the statute, then the landlord and the tenant can agree right there, hey, this place is no longer tenantable. It's an act of God that's caused this, or it wasn't an act of the landlord or not an act of the tenant. It was an act of some other happening of a third party. Then at that point, they can either go ahead and terminate the agreement altogether. The tenant can move out and there's no obligation to pay rent from that day forward. Or if it's just a part of it, say it's a spare bedroom that now has this problem, then at that time, you can go ahead and agree to reduce rent by whatever value you can agree upon that room might be worth. And go ahead and stay. I mean, and there might be some value to that if you really like the place that you live. You've got a great relationship with your landlord. You've been there for 5 years. You have children that enjoy being in the school that they're in.
Right.
This really is a minor problem. Maybe the hole is in the garage or something where you can park your car outside. Probably come up to an agreement and say, hey, we're going to reduce rent by a couple $100 a month for the lack of the garage.
All right. Now let's talk about the duties of the landlord. Tell me about that. If you're a landlord, you should be listening to this.
Well, the landlord's duties and the ones that are probably fit for covering today regard the basically what do you have to do with the security deposit, and then what are your duties with regard to the dwelling unit. And a little third offshoot of that is, what is it that you're absolutely not allowed to do? The first part is the deposit, and that's governed by the statute. And what the statute says is that basically the landlord has three options of what they can do with a security deposit. And let's differentiate a little bit here about what a deposit is. If it's first, last, and security, the first would be the next immediate month. So the landlord can take that check when you move in, or when you give it to them, it's the next immediate month. They can probably take that and deposit it in their own account. If you're giving a last month's rent or a security deposit, then that needs to be either held in a separate non-interest-bearing account, needs to be held in a separate interest-bearing account, whereby the landlord, upon return of the deposit, has to pay, I believe it's 75% of the interest earned, or 5%.
Okay.
Or they have to post a surety bond with a surety. Mostly when I speak with landlords, and the interest rates that are available today, that you might get 1.5% or
nothing,
or nothing,
really.
Near nothing.
Right.
It's not worth it to keep it in an interest-bearing account and do the math.
Now, when the landlord takes the security deposit, do they have to? I'm from New Jersey, so I think they have to tell the tenant what bank it's being held in, what account number. In other words, they have to provide proof that it was actually being held in escrow. Is that required here in Florida?
Well, if the landlord has more than 5 rental properties, then in that case there's information that has to go inside of the agreement or has to be provided to the tenant within 30 days of entering into the agreement. And some of that is there that they need to identify the institution where the money's going to be held. The other part of that is what happens at the end of the lease. Let's say that it's either that there was a termination because the lease expired. It was a 1-year lease. The time came up. Tenant moves out. What happens in that scenario? Well, the landlord has basically 15 days to return the deposit to the tenant, or has 30 days to notify the tenant of their intention to impose a claim against the deposit
For damages and things that were wrong on the property or garbage that the tenant left behind. The tenant left behind, and they have to clean it up, kind of thing.
Yes, if the tenant left the place in disrepair, and you can think of different things like broke some blinds, or the landlord got the apartment back and it looks like somebody took apart a Volkswagen in the middle of the beautiful white carpet or something. That there's stuff that has to be done as far as those things. There's 30 days to impose the claim. One thing that I think I missed here was the language that goes into the lease, if the landlord has more than 5 units, also tells the tenant that it has a duty, and that is that the tenant needs to provide a forwarding address at the end of the term of the lease. This makes sense, and probably makes sense to do anyway, so that the landlord can send you this notice. Either A, send the check, or B, send the notice that they're imposing a claim. If they send the notice they're imposing the claim, then the tenant then has 15 days after receiving the notice to go ahead and object to the imposition of the claim. And that's kind of where the dispute, if you read what the notice is supposed to say in the lease, it also says that the tenant should try to work things out basically without going to court.
Okay.
It says you should try to
Communicate with the other party.
Resolve this
But if you
without
can't,
filing an action. But if you can't, then that's the time when you would want to institute an action over your deposit.
All right, I'm going to jump in for a second because we're going to talk more about the landlord side. We're going to take a quick break, and we'll be back in just a moment.
Use time after time. I've done my
Consumers, do you have bad credit? Can't purchase a house or car? Paying too much in interest on your credit cards and loans? Scammed by credit repair companies? There is hope. You can get back on track and do it the right way. Call Credit Education Consultants today at 813-500-6064. That's 813-500-6064. Or go to crediteducationconsultants.com now and get the help you need. Don't delay. Call today. Mortgage reps and realtor inquiries are also welcomed.
Do you need a private U.S. address for your home business? Do you need help packing and shipping? Are you tired of keeping your inventory at home? Do you need a storage space to store your merchandise? Helpship.com is a domestic and international shipping and packaging service company that can help you with your shipping needs. No matter where you live, we can forward anything to anywhere for you and your customers. Our services range from packing consolidation service, mail forwarding service, shopping assistant, and much more. We're rated A on Better Business Bureau. Expand your business to the globe with us. Please visit helpship.com for more information.
Don't turn it off now. You need this stuff. Tampa Bay's Tan Talk Radio Network.
Welcome back to the Half Empty, Half Full radio show. I'm here with attorney Townsend Belt, and we're talking about landlord and tenant law. Now, I'm going to give you a scenario. Let's say that I own a property and I want to rent it out. And maybe I want to put certain things in the terms of that lease. For example, can I put things like if it's a house, that the renter is responsible for maintaining the yard, the landscaping of that property. What if the tenant, as we discussed earlier, what if the tenant does damage to the property? The toilet gets stuffed up and it overflows, but they call me and they want me to pay for it. How do you designate in words into a contract to have the tenant be liable for certain things? Do you understand what I'm saying? As opposed to the landlord. And are there certain things that can't be included that if I am the landlord that I can't tell them to do? I throw you the doozies.
I think it's like a yes, and a yes. But
okay.
Yes, you can certainly shift duties, especially on a single family residence, to the tenant. The second one was, if the toilet overflows, is the tenant responsible? And in jumping kind of to a tenant's duties, yes, a tenant's responsible if the tenant causes a toilet to overflow.
So it's determined by who caused the damage. If I, as the landlord, had a major problem with the water lines or the pipes, then it would be my responsibility. But if they actually caused the damage, then they would be responsible to fix it.
It's not that clear cut.
Okay.
The landlord has to comply with the requirements of the applicable building, housing, and health codes. Okay, so that's under 83.511. If there are no applicable building, housing, or health codes, then the landlord has to maintain the roofs, windows, doors, floors, steps, porches, exterior walls, foundations, and all other structural components in good repair and capable of resisting normal forces and loads, and the plumbing in reasonable working condition. So if the toilet overflows because the tenant's child was trying to flush, their teddy bear down it, tenant's responsible. If the toilet overflows because it's not in good working condition or because the landlord somehow had violated the building, housing, or health codes or was failing to keep it in a good working condition, then the landlord might be responsible. But if you look at the duties under 83.51 or .52, the tenant also has an obligation to comply with all the applicable building, housing, and health codes. So the tenant can't tinker with something in the house and make it violate that, or else they've violated the act also.
Gotcha. All right, well, let me ask you another question. What if a tenant leaves and does not provide a forwarding address, and maybe they've done more damage to the property, or they've stolen property, like appliances, for example, that are usually left in the property by the landlord? Now they've skipped out of town, no forwarding address, can't track them down. Well, of course, you're not going to be able to return the deposit because they already know they've lost the deposit, but maybe they've done $3,000 worth of damage, but the security deposit, say, was only $1,500. Now the landlord has lost the $1,500. Well, what happens in a case like that? Because maybe you can't track them, or they've moved out of state. What do you do?
Well, quite frankly, we run into that a lot.
Right.
What you do is you can turn the tenant over to let's say that when this happens, okay, first of all, that's not the extent of the problem. The problem really is that the tenant was also 2 months delinquent on rent, got an eviction notice, and then decided to bail on the unit and take the stuff with them and, break the mirrors and write in ink on the walls. There's usually more going on than just that they took the stuff. But the landlord would have an action against the tenant for whatever damages were caused. The 83.49, the deposit question becomes then, there was no forwarding address listed. The statute used to say you have to send the notice to the last known address, which often was the rental unit.
Okay.
So a landlord's in kind of a bind in that situation. If they have more than 5 units, there's now a duty underneath the contract for the tenant to provide this the forwarding address. The tenant hasn't done it. So what does the landlord do? I think you're in a kind of a situation where the tenant at that point has breached the lease and breached the act. And in essence, the landlord would be...
The landlord's stuck.
Is stuck. They can't comply by sending it to the new address. But I think for purposes of cover your bottom, I would send it to the last known address.
Like certified mail.
Certified mail. And
do that.
And if they had maybe the tenant left a forwarding address at the post office.
Yeah, I had a friend who owned a property in this situation. That's why I asked. And what she had done was to contact a collection agency, and they were able to skip trace, I think, through the Division of Motor Vehicles, and actually placed it onto their credit report, which, ultimately, if that renter wants to buy something down the road, there's going to be a huge amount to pay. So it's damaging to their credit report, and they obviously won't be able to buy something with it on the report. But again, I don't know that she ever collected any money as a result of that. But there was a lot of damage, a lot of things, stolen from the property. And one of the key things is I think a lot of people, when they sign leases, and I'm talking about the renters, is they don't actually read it. It's kind of like when you go to the doctor's office and they give you the HIPAA notice and they say, just sign here. I'm probably one of the few people that actually reads the HIPAA notice. When somebody gives me a contract, it's my signature and it's legally obligating me to the terms of that agreement. But a lot of people don't even read the agreement. And do you think that that's true in a lot of cases? And it could be from either side, but usually it's the landlord that's written up the agreement, and then the renter has to read through it and sign it. And you need to actually read what it is you're signing and what your obligations are. But what happens is a lot of renters end up in bad situations financially, and they don't seem to have any respect for the person that is giving them a place to live. And now they're angry because they're probably going to get evicted, and they turn their anger to the landlord and say, well, I'm just going to take everything, or I'm going to do a lot of damage. Just like in the foreclosure scenarios where people were, kicked out of their houses, and not always legally, but you heard stories about, there was one guy who actually rented a major piece of equipment and drove down his house, literally crashed the house down to the ground. So you have to be fair. You have to look at what it is that you're signing and then follow those rules. And that's sort of where I kind of take issue. But let's talk about the duties of the tenant with rent and their obligation. We talked a little bit about maintaining it. What about the enforcement of rights? Talk about the civil action and criminal offenses.
Well, to not let us move too quickly,
sure.
There's another thing that's available to a landlord, or another remedy, and that is if the landlord knows that they're let's say that they're have an action for possession against the tenant, or they've terminated the lease and informed the tenant, hey, you've not paid rent or you're not complying, and so I'm terminating the lease. If they see that the tenant is destroying the premises, the landlord can seek an injunction from the court on an emergency basis and say, hey, I want an emergency injunction enjoining the tenant from doing any further damage or taking
Well, how do you do that? Let's say I have a tenant, and maybe it's as simple as they're not watering the yard, and the HOA now starts sending me the notices saying, the property is going to need to be resodded, or you see some type of physical damage to the structure. Maybe they're disobeying the HOA and they're getting notices, things like that. How can you enforce it under that contract? Even though they've signed that contract, by the time you evict them, you're probably going to end up taking the loss as the landlord. So what do you do in a case like that?
So what you do in a case like that, and it's a little bit muddier than what the other violations aside from failure to pay rent are always a little bit muddier than what the failure to pay rent is. Failure to pay rent is very simple. You post a 3-day notice to pay rent, or we're going to have an action. We're going to terminate the lease and have an action for possession. If you look at 83.56 regarding the landlord's duty, if there's a material failure to comply with 83.52, which was the part where the tenant has to comply with building, housing, and health codes and other requirements statutorily imposed on a tenant, or if it's a material provision of the rental agreement. Let's say that I believe in your example, the tenant was renting in a place where there was an HOA. It's probably a good idea on the landlord's behalf or on the landlord's part to put in their lease to say the tenant will comply with all of the HOA, the CCRs is what we call them, but the covenants restrictions of the HOA.
Okay.
And it probably would be if there's any type of maintenance and it's been shifted to the tenant, like the landscaping or yard, then the landlord is allowed, you can give a notice that they're going to terminate the agreement. But the kind of difference here is the way the statute reads. It says if such noncompliance is of a nature that the tenant should not be given the opportunity to cure it, then the landlord can terminate the lease effective immediately and give 7 days notice to the tenant, or 7 days for the tenant to move out. If the tenant doesn't move out, the landlord can file an action for possession. But the Act also says if such noncompliance is of a nature that the tenant should be given an opportunity to cure it. So, hey, maybe there's a citation from the HOA that the yard hasn't been maintained. Then the landlord is supposed to give another 7-day notice, but this says, hey, correct it, mow the yard.
You have the opportunity to correct it, or ultimately you're going to have to move out.
Right. And so the hard part there is really drawing the distinction of when is it that the tenant should not be given notice, when is it that the tenant should be given notice. The examples given in the statute of when the tenant should not be given notice are if the tenant is destroying the property, if there's damage or misuse of the property by an intentional act, or if there's continued unreasonable disturbance. And so I kind of look at the continued unreasonable disturbance as the fourplex landlord that has one person they rented to that's really irritating the other three. And the landlord should always document if they get complaints from these other people, so that if they ever have to go to court and say, hey, I had to get rid of this tenant, my other three tenants were threatening to leave, they've been good tenants, they've lived there for a long time, they can say, look, I've got this backed up with some records that say, hey, I've gotten a complaint from Unit A, B, and C about Unit D, and I've given them opportunities to cease their conduct, and they didn't, so I'm coming in to evict them.
All right, gotcha. And we're going to take a quick break. We'll be back just a second.
Time after time, I've done my sentence, but committed no crime.
Do you need a private U.S. address for your home business? Do you need help packing and shipping? Are you tired of keeping your inventory at home? Do you need a storage space to store your merchandise? Helpship.com is a domestic and international shipping and packaging service company that can help you with your shipping needs. No matter where you live, we can forward anything to anywhere for you and your customers. Our services range from packing consolidation service, mail forwarding service, shopping assistant, and much more. We're rated A on Better Business Bureau. Expand your business to the globe with us. Please visit Helpship.com for more information.
Hello, I'm Jim Velasquez. Does getting a lousy 1% on your CDs make you sick to your stomach? Inflation is hovering at 3%, so what's really happening? Allow me, Jim Velasquez, to send you my free report. If you haven't reviewed your CDs in a while, don't get this report. It will break your heart. If you want to fight back and beat the bank, text RETIRE to 72727 for this free report. Let's beat the bank. Text RETIRE to 72727 for your free report.
Do you suffer from back, neck, or body pain? Do you suffer from migraines or have jaw or face pain? Has conventional medicine failed you? Were you injured or in an accident? Call chiropractic physician Dr. Dan Maddock at 813-935-1664. Dr. Dan has helped thousands of patients gain relief for more than 30 years. Dr. Dan is caring, gentle, and takes his time with each patient. He's also a past president of the International Craniopathic Society, a special certification of only 300 chiropractors worldwide. Dr. Dan helps patients from the neck up and the neck down. Dr. Dan accepts most insurance plans. Don't continue to live in pain. Call 813-935-1664 today. That's 813-935-1664 and get on track to better health. Consumers, do you have bad credit? Can't purchase a house or car? Paying too much in interest on your credit cards and loans? Scammed by credit repair companies? There is hope. You can get back on track and do it the right way. Call Credit Education Consultants today at 813-500-6064. That's 813-500-6064. Or go to crediteducationconsultants.com now and get the help you need. Don't delay. Call today. Mortgage reps and realtor inquiries are also welcomed.
Time after time.
And welcome back to the Half Empty, Half Full Talk radio show. I'm here with Townsend Belt. He is an attorney, and we're talking about landlord tenant law today. Let's talk about some of the remedies. First, let's go back. What are some of the common mistakes that tenants make?
Well, the most common mistake I kind of see with tenants making is comes down to a basic kind of, I would say, like a misunderstanding of how the landlord-tenant relationship works. And everyone seems to think it's a two-way street, but it kind of is not. There's duties that are created for the landlord, and there's duties created for the tenant. And the way it really seems, the way I describe it as operating is that, in truth, it's really two one-way streets, unless there's a reason that it should not be, or unless you're given a reason that it should not be. And I'll give a good example of it. I will often get a phone call, and the first thing the tenant says is, "Oh my gosh, did you get my pictures?" "Yes, I got your pictures." "The place is covered in mold, and or there's cockroaches coming out of the whatever, or look at the hole in the roof and there's water pouring into the master bedroom, or you name the problem. And I know that from looking at it that most likely there's what I say is an 83.51 problem, a failure to maintain the premises problem. But what happens is the second questions that I ask are, well, are you current on your rent? No. I stopped paying rent because the place is a mess. Well, that might be okay. Did you give the landlord notice that's required under 83.56 that you have 7 days? What the statute requires is that you give written notice and give the landlord 7 days to fix the problem. And if not, then you can indicate in your notice whether you want to terminate the agreement. Say, hey, you know what, we're moving out. Or B, you can withhold rent. Well, the duty to pay rent has come up, and so the landlord can still file their action for eviction.
Because you as the tenant didn't notify them to say, hey, there's an issue.
Right.
In other words, that's your obligation as the tenant. If there's a problem, is to, I've always been taught, document everything. It's not just a phone call, because everybody can say he said, she said, but you document it and send it certified return receipt. And I don't think a lot of people know that. And now that's where the problems begin, correct?
Yes. I mean, I hinted at it earlier, but that's where the notice provision in the lease becomes very important, is that if the landlord has given you the method to give notice, always give it that way. I think then you've complied with your lease, you've complied with the act. You're kind of you're in the right. That's not to say that this part of the Landlord Tenant Act gets tricky, and that's not to say that you still wouldn't have some sort of action against the landlord. Perhaps it's just a matter of when you're setting yourself up for this type of problem, what generally happens is the tenant texts the landlord, hey, buddy, there's a problem here. I'm not going to pay you rent until it's fixed. Or they text the landlord's property manager this. And that's not
a formal
probably
notice.
Not good enough underneath the notice to the landlord in the lease. And it's not good enough because the notice inside of the act is required to be in writing. And they don't notice them that, hey, I'm not going to pay rent, or I'm going to terminate, or really fully apprise them of what the intention is. And so they don't have the right to withhold rent now. So the second thing that I ask is, well, if the landlord now files an eviction action, or if they've received now a 3-day notice for failure to pay rent, do you have the money to pay into the registry of the court? And that brings up a problem where under the Landlord Tenant Act, if you've received a 3-day notice that says that you haven't paid rent, if they file an eviction action based upon the failure to pay rent, in order to defend against that action for eviction, the rent has to be paid into the registry of the court, or the tenant has to have a motion to determine rent filed with the court within the time allotted. Let's just put it this way: in addition to what they have to do as far as answering the complaint.
Right. What you're trying to say is the tenant has to put the money aside. It's not going to the landlord, but it's going to the court or some type of an escrow account.
Right.
So that they're still following their part of the agreement.
If they get served with the complaint, then they need to deposit in the registry of the court or file a motion to determine rent. But what ends up happening is, well, no, I didn't do that. I ended up hiring somebody to come out here and do all this stuff. Now I don't have the money to go into the registry of the court. Well, that's going to cause a problem. Procedurally, that causes a problem with an eviction. So the second thing really is that the tenant needs to pay rent unless one of these very few violations on the part of the landlord has occurred. So what the tenant probably should do, and I mean, this is kind of my suggestion, is if you have a problem and you say, hey, there's a water spot in the ceiling, it appears that there's a leak in the roof. Notify the landlord in writing of it. Contact your building, housing, or health code inspector if there is one locally. If you're in Hillsborough County might have a code enforcement, or Pinellas County. Have them come out and determine whether or not there's a code. Okay,
so let me ask you then. If somebody has followed all of the terms of the rental agreement and they have issues, and they've done everything in writing, and the landlord still hasn't done what they're supposed to do, is this the point at which they should contact an attorney, or, if you're here in Florida, to contact you?
They should probably contact an attorney before that.
Okay.
Because what's going to end up happening is they're going to get 9 times out of 10, the landlord's going to send them an eviction notice. The things that I would probably like to go ahead and leave everybody with are basically read your lease, preferably before you sign it. If you don't understand something, you're entering into an agreement that's probably worth thousands of dollars over the year that you're renting a place. It's also probably worth, if you don't like a provision in it or you want an explanation, to pay somebody to review it for you. Once you sign the lease, keep a copy of it someplace safe. It's very important. It governs your relationship with the landlord. If there's a violation of the building, housing, or health codes, call the appropriate department to investigate it. If you think there's a violation of your lease or statute, call an attorney. There's far too many laws regulating you for you to know.
And now, real quick, just give me, I want to thank you first for being here today, but give out your phone number in case somebody wants to contact you.
813-251-8630.
Great. Thanks, everybody, for tuning in. Join us every week for a new half-empty, half-full consumer advocacy talk radio show. Learn something new every week and get smarter faster. Be safe.
I've done my sentence, but committed no crime. And bad mistakes, I've made a few.
At the Oaks of Clearwater, you'll enjoy a lifestyle to fit your needs. From independent living, assisted living, memory care, and skilled nursing. Our exciting independent lifestyle is the perfect combination of freedom, comfort, and security. Enjoy total independence with peace of mind. Our independent lifestyle includes chef-prepared meals in our beautiful waterfront dining room, a continental breakfast, all utilities, including cable and telephone, housekeeping with linen service, scheduled transportation, including trips for shopping, local restaurants, theater, and more. Our activities program is second to none. At the Oaks of Clearwater, you'll enjoy affordable luxury waterfront senior living with $1 million view. Call today, 727-445-4069, and discover where caring, compassionate service really makes the difference.
Arg, matey. When it's time for lunch, when it's time for dinner, when the show's over, when the day's over, when it's time to chill, where do we go? Over to Naughty Nancy's Food Shack and Crow's Nest Pub. It's literally in our backyard, right in back of the WTAN studios at 700 Eldridge Street, just north of downtown Clearwater. Just look for the broadcast tower. Nancy's food and atmosphere get rave reviews. The laid-back patio is a great place to hang out, dine, and listen to live music at night. And Nancy's one of the friendliest proprietors in town. And now, Nancy is serving Sunday Jazz Brunch from 11 a.m. to 2 p.m. Brunch served with Eggs Benedict, crepes, waffles, lox and bagels, shrimp, oysters, and a build-your-own omelet. That's all at Naughty Nancy's Food Shack and Crow's Nest Pub, 700 Eldridge Street in Clearwater. That's right where Eldridge crosses the Pinellas Trail between Myrtle and Fort Harrison. Call 446-3717. 446-3717. You're listening to the Tan Talk Radio Network.
I am disgusted with your sharing of health problems. Who in the world wants to hear about your freaking problems?
Sorry, Bill, that I have cancer and it's bumming you out in your pathetic little tedious life. Here's what I want you to do. Get in your Crown Victoria, get it going about 90 miles an hour, and take it into a concrete bridge above.
Heard the new Imus lately? On the stations of the Tan Talk Network. Catch Imus in the morning, right here. Don't turn it off now. You need this stuff. Tampa Bay's Tan Talk Radio Network.